So, in essence, what we have today is a long, really long term, because it's possibly and probably one of the most complicated aspects in terms of general international law, and it is the law of state responsibility. And most precisely, the work adopted back then in 2021 and in 2001, sorry, by the International Law Commission, with the back then time draft articles, now articles on state responsibility for internationally wrongful acts. So as you may see, of course, if you're Jessup participants or if you are interested in participating in the Jessup has a fundamental and essential element in all the cases that it presents in all the editions, and it is questions regarding responsibility. Responsibility can be measured in terms of who should be responsible and what should do the state that it's allocated as responsible, what should be the proper course of action. So the articles on state responsibility were adopted by the International Law Commission, which is a set or a group of experts appointed by the United Nations members in somehow to oversee and supervise and analyze the situations of international law. More precisely, the International Law Commission members are appointed by members of the General Assembly of the United Nations with the purpose mostly to crystallize and codify customary international law, but also to identify a new set of rules that may be consistent with reiterated and pro proactive practice of states that should or may have the possibility to become customary international law. That was precisely something that happened with the Articles of the State Responsibility. The Articles of the State Responsibility were adopted under the framework of the ILC mandate to crystallize and codify customary international law. But one of the most interesting elements about the Articles on the State Responsibility is that not this entirety of the set of articles is to be considered as up-to-date rules of customary international law. And the International Court of Justice has been quite proactive in analyze which rules of these articles that we're going to analyze kind of generally are part of customary international law and which are not, or yet are not in somehow reach that threshold as to be considered part of customary international law, but they are part of the process of crystallization. So, as I previously mentioned, the UNILC Articles on State Responsibility for International and Wrongful Acts are a set of guidelines that clarify the legal obligations in cases of international and wrongful acts. So the articles, as you may see now, are mainly divided in two kind of aspects of analysis. Of course, the articles are divided in specific terms in four parts, but the major aspects that the International Law Commission analyzed back then was what should be considered an internationally wrongful act and what should be the consequences of the responsibility for such internationally wrongful acts. They were, of course, developed by the International Law Commission in the context of the growing importance of international law and state responsibility, more precisely as to certain questions arising for even ending uh, this outbreak of general conflicts that happened in the late 90s and early 80s as well, in which there was no clarity whatsoever in what should be the proper course of conduct of the international community when analyzing breaches of international law. So the history and current status of ARSIWA is kind of resumed for what I just mentioned. ARSIWA stands for the Articles on the State Responsibility for International and Wrongful Acts. Do not confuse, because this is a common mistake to say that draft articles on the state responsibility for international and wrongful acts, because they are not draft now. They are articles that were presented and adopted under the framework of the General Assembly. The more specific term in that moment in the resolution of 2001 was that the United Nations took view or that it considered the articles. So therefore they were in draft. That said, that they are not in a continuous work in progress in terms of what should be presented on the article, but rather the articles already exist. So they are implemented. But of course, as I just previously mentioned, the relevance of these articles relies on its application in international disputes among states, more precisely, the views adopted by international criminal tribunals, arbitral tribunals, as well as the International Court of Justice as interstate disputes. ARSIWA articles were adopted in 2001 by the International Law Commission and then presented to the General Assembly of the United Nations, in which, as I mentioned, they took view and accepted in somehow the work of the International Law Commission. Its original intention was to be a set of guidelines as in order to analyze what should be the proper elements and the proper requirements in order to assess when an state is responsible and which type of actions arise to the level as to be considered internationally wrongful acts. These articles, as of today, have been essential in the work of international law, at least when analyzing state responsibility. Normally, there is like a misconception that the articles of the state responsibility are only on the service of the International Court of Justice or even its prior works to the Permanent Court of International Justice way back then. Yet, however, as of today, you can see that analysis of articles on the state responsibility have been made in different forums. As I mentioned, criminal international law, interstate disputes, arbitral tribunal disputes, as well as relations into domestic and international levels of state responsibility, more precisely human rights forums of international law. As, for example, the Inter-American Court of Human Rights, you have also the European Court of Human Rights, so the African Commission for the Protection of Rights and the People. So they have been essential into analyzing the questions of this type of situations because, in essence, one of the major concerns of international law when in somehow regulating how states relate to each other is what happens when there are conflicts or judicial disputes between such states. How are we going to assess or how we are going to define criteria in order to analyze such levels of responsibility? So RCW includes not only provisions in relation to how to attribute a conduct to a state, but also includes various kinds of provisions of significant importance in international law, such as the mechanisms of reparation, what should be understood as a continuous internationally wrongful act, what should be a mechanism of satisfaction and guarantees of non-repetition. And it, in general, has been defined as the general standard and framework of international law that helps to maintain order and stability when analyzing responsibility of states for international wrongful acts. So, in essence, the major aspects of the part one of the articles on the state responsibility for international wrongful act is to analyze what should be considered state responsibility. The state responsibility is even prior to the codification or even crystallization of customary international law and the work adopted by the International Law Commission, but rather state responsibility is a core fundamental principle of international law that holds that states are accountable for their actions and omissions in relations to other states or the individuals of other states, or even its own individuals when such relations are governed by mechanisms of international law. In consequences, it encompasses a wide range of legal obligations and duties, including those arising from treaties, customary international law, general principles of law, as well as other set of rules that may be as an auxiliary means of interpretation in terms of these core sources of international law. So the definition of a state responsibility as defined in ARSIWA is that a state responsibility refers to the legal and moral obligation of a state to compensate for an internationally wrongful act. And I use the word compensate because, normally the general term is to repair the damage caused by an internationally wrongful act. The most common way of reparation is not restitution, but rather compensation. And we will go in the last part of this session, we are going to see why. But this major essence is to present a set of rules in order to demonstrate that there is a breach of an international obligation, that such breach of an international obligation is attributable to one state, and that the legal consequence of such breach should be the implementation of what the articles on the state responsibility called remedies. But these rules have requirements. They are not just guidelines in general terms, because more precisely in kind of back 80s developments of the International Court of Justice, late 90s and beginnings of the 2000s, um, some of these rules have and are considered to be mandatory in terms of analyzing responsibility. For example, you have the case concerning armed activities in the territory of the Congo, the Bosnian genocide case, the military and paramilitary activities case that have, and even the North Sea continental shelf cases of the International Court of Justice, in which has been defined that parts of the articles on the state responsibility are not just mere guidelines, sorry, but rather they are rules of customary international law. More precisely, in one of the recent developments of the International Court of Justice in the case concerning the application of the Convention on Prevention and Punishment of Genocide, it said and reaffirmed what was being told back then in 2007 in the Bosnian genocide case in relation to that the rules regarding attribution, remedies, and some part of the circumstances precluding wrongfulness should be considered as parts of customary international law. Yet, however, articles on state responsibility are more wider and more extended than just these three major parts. Normally, when you think on the articles on state responsibility, you immediately think in the proper analysis of the state responsibility, which is attribution, breach of an international obligation, and the remedies. So therefore, you think that the articles only refer to this type of situations. Yet, however, there are other interesting situations defined in ARSIWA, such as what happens with the involvement of other states in commission of international and wrongful acts that should be analyzed when assessing questions of the Jessup competition, and even in not only in the arena of moot court competitions, but also when analyzing state responsibility. So before continuing, a breach of an international obligation and a definition of a state responsibility includes, of course, these two major elements, which are to be considered the breach of an international obligation and the attribution of such conduct to one state. So the scope of a state responsibility can arise, as I told you, from a different variety of acts, such as breach of treaty obligations, violations of customary international law, violations of peremptory norms or use guidance norms. So you have to analyze in terms of breach of an international obligation, what is the obligation breach in which instrument, if there is any instrument, of course, contains the obligation, which type of source is the one that define the obligation and define the scope of the obligation of such international character. So as I told you, there are in criteria of state responsibility three major aspects to analyze: the attribution of conduct to a state, the breach of an international obligation, and a set of rules of exceptions in which is not yet to be considered permissible, but rather that there are situations in which, by the nature of the situation, you may be allowed temporarily to engage in violations of your obligations, which are the circumstances precluding wrongfulness. So attribution of conduct to a state is that fundamental element that there is no international obligation to be breached if there is no attribution, if there is no state responsible for such breach. There is, of course, other set of rules in which there are other actors, such as international organizations, that may commit internationally wrongful acts. But when pertains to ARSIWA, the major element in question is to analyze whether the action in question was committed by a state or not. It's interesting because some people tend to think that the first thing you have to do is to characterize the breach of the international obligation. Because, of course, if you don't have any breach, then you don't have to analyze the questions of attribution. Yet, however, if you see the structure of the articles on state responsibility, what is presented first as an element of analysis or as an element of research is the elements of attribution. Of course, the first part of the articles on state responsibility refers to these general principles that I have mentioned. But yet, however, when you are going to do the specific case by case analysis, the first thing you have to do is whether the act in question should be or could be or had the potential to be attributed to one state. So the general rule of a state attribution of a conduct to a state is, of course, that it is committed by state organs or state officials. But there are some other gray area situations in which it is not that clear the involvement of a state and actions of the state. Then, of course, ARSIWA present the question of how to characterize a breach of an international obligation, and that is the state's failure to comply with its obligations under international law, and it is a necessary condition for establishing the state responsibility for an international wrongful act. And then you have the circumstances precluding wrongfulness. There are, as I previously mentioned, but we are going to assess more deeply in the middle part of this presentation. Um, such circumstances that may preclude the wrongfulness because of its characteristics in somehow creates a scenario in which it is in somehow permissible to engage in courses of action non-consistent with international law. So in the image that you are seeing and in the slide that you're seeing, or the photo, the slide, but also the photo that you're seeing one of the most emblematic cases, at least in terms of what should be attribution. And it is not the case concerning military or paramilitary activities in and against Nicaragua, possibly one of the first cases that tried to assess a comprehensive analysis of the vast majority of the rules depicted in the chapter related to attribution of conduct to a state. It is not also the the case concerning United States diplomatic and consular staff in Tehran, but rather, as you may in somehow derive from the image from the cases that I mentioned, this is the Bosnian genocide case. Although it is one of the most recent in terms of, well, recent in terms of analyzing self-state responsibility, it was a decisive decision of the International Court of Justice in many, many areas of international law, most precisely in terms of human rights law, international humanitarian law, and international responsibility in comparison to criminal international responsibility. And what I decided to pick or to choose this particular picture because the International Court of Justice in relation to the Bosnian genocide case has an entire chapter not only pertaining to what we are going to see one specific rule of the articles of state responsibility, but rather has an entire chapter of what should be understood as attribution of conduct. So in general, in order for a state to be held responsible for an internationally wrongful act, it must be shown or demonstrate that the conduct in question can be attributed to the state or its official. This can include acts of its officials or representatives. And this is when questions arise as what should be considered an official and what should be considered a representative. So you have persons that are by law empowered and entrusted to represent the state. Yet, however, there are some situations in which the law may be not that clear or maybe not to be as to the level of sufficient as to demonstrate that a person or a group of persons are acting on behalf of one state, and what is the relation of such state in relation to this person or this particular group of persons. So the chapter of attribution of conduct to a state created a set of rules beginning from Article 4 and ending in Article 11 that are defined or are considered to be the general rules of attribution on the articles on the state responsibility and part of customary international law. So attribution of conduct is essential, and it is an essential element of state responsibility for what we have been discussed, or what I present to you, is that in order to demonstrate responsibility, at least in this international arena, you have to demonstrate that there is a state involvement. The rules of attribution are based on the principle of that a state is responsible for the acts of any person or entity that acts on its behalf. And this is the tricky question. what should be also understood and acting on its behalf. And the International Law Commission tried to resolve this question by establishing a couple set of rules, which we are going to see now, which are the specific rules of attribution. So you have Article 4, which is the general rule of attribution, which is the conducts committed by organs of the state or its officials. You have Article 5, which is the conduct of persons or entities exercising elements of governmental authority or exercising governmental authority. You may question yourself, what is the difference between Article 4 and Article 5? So remember that in the general rule of attribution, there is a mandate of one person, a particular group of persons, empowering them to exercise a representation on behalf of the state. And this representation may not only be seen in terms of international representation, but rather acting on behalf of the state under specific circumstances. On general circumstances, sorry. Article 5 deals with an exception. It's what happens when you in somehow delegate a public function to a specific group of privates or to a person. So, for example, and if you look upon the comments on the articles on the state responsibility, one of the most clear examples was an arbitral award of Canada, in which was analyzed whether Article 5 shall be applicable when assessing the responsibility of private companies that exercise public functions, such as, for example, transport or maintenance of highways or even trailways. And it was considered that mobility in one state and interstate connection is by nature a function of the state. Yet, however, remember that the state it's allowed to engage in actions on different levels. You have the sovereign actions, which are considered to be the acta iure imperi actions, which are actions of the state acting as a state, and you have acta iure gestionis, or actions committed by the state as it is to be considered a person or a company. You can delegate functions in both senses. Normally, the delegation should be only, as the articles and the state responsibility presented in the Acta Iure Gestionis case, that is, actions that are not exercised by the state as a sovereign. For example, you don't delegate your international representation or your international relationship with other states, but rather, for example, more functional and even commercial activities. So there is one particular case in relation to this particular article mentioned and analyzed even by the Jessup competition, and what should be the responsibility of private companies. I believe it was, I believe not, it was the case of 2019 when analyzing whether what should be the rule applicable when private companies that have close relation to the state develop functions that are normally of the conduct of a state, such as public research, maintenance of healthy. So this article focuses on that specific set of rules when a private is entrusted to exercise elements of governmental authority. The fundamental question in relation to Article 5, and this is possibly one of my favorite articles and set of rules on the articles on state responsibility, the rules of attribution, but more precisely Article 5, which is really close to my heart for many reasons, as you may conclude. Um, Article 5 poses a tricky question, and it is what should be considered a governmental function and what should be considered a governmental authority. And the draft articles on the state responsibility back then, when they had their comments, because when the articles were adopted in 2001, they were not adopted with their respective comments, but rather the comments were in somehow guidelines or interpretative notes in relation on the scope of application of each specific article. But if you see upon the comments on the back then draft articles on the state responsibility, it says that what should be considered governmental depends on the own state history and traditions. But there is of course certain criteria that should be met. That is that it is normally developed by a state, that the state in its history has considered such function as to be of governmental function, and that by some particular reason or for a strategic or for a strategic reasons, is delegated into particulars. So there are questions into pertaining whether are the different capacities of states in terms of actions that are normally or not normally uh, developed by states. You have states that are really powerful in terms of research and development. You have states really powerful in terms of healthy provision and health insurance. So there is in somehow of subjective criteria as to determine what should be considered a governmental function. And that's the fundamental question of Article 5. Then you have Article 6, which are conducts of organs placed at the disposal of a state by another state. This is in somehow easy, but also tricky. And that is whether you have organs that are in somehow entrusted by one host state uh, that come from another state to exercise such function. So let's assume what happened in Article 5 and I delegate, but rather than delegating my research investigation or even some maintenance of security in my territory, I don't delegate it to private, such as normally happens when you delegate this function to the persons in charge of security, which are not normally part of the government in terms of maintaining security in private companies, for example, the vigilant. That's a public function exercised by a private. But now imagine that such function is delegated to an organ of another state. So the conduct of the organs placed at the disposal of a state by another state should be considered an act of descending state. So, for example, if I send but also, and there is a tricky question, what is the extent of responsibility? Because you have a sending state that sends delegates or functionaries to exercise particular functions of the state to one state, and you have the receiving state. So the question is, what state is responsible in terms of Article 6, the sending state or the receiving state? So you have to in somehow break down what says the article, the literature of Article 6, which says that conducts of organs placed at the disposal of a state by another state shall be considered as act of the receiving state, but also there are a set of rules that analyze the responsibility in relation to the sending state. So, for example, if I am the receiving state and I am in somehow helped by another state in the exercise of a function, the actions of such delegates of another state, which are placed at the disposal to me, are responsibility to me because I accept them in my territory. There, of course, is Article 7, which is the access of authority or contravention of, of instructions. So imagine the rule of Article 4. And Article 4 says that there is, of course, there are some questions, that there is responsibility in relation to actions of a state committed by its own organs. But what happened when a delegate of my state commit its action in contravention of its mandate or its public mandate or its function, whether I should be responsible or not? In pursuance to the articles of state responsibility under certain circumstances, either acting on excess of authority or in contravention to the mandate or instructions that you have, yet however the state retains the responsibility because it has in somehow a power of overseeing the actions of its function. And this article is derived from the principle that a state should be in somehow capable of foreseeing the actions of its officials. You have then one of the most complicated and one of the most debatable in international law standards on terms of attribution, and it is direction or control. Many people tend to confuse direction or control, but they are different. One thing is direct and one thing is control. The vast majority of the debate in terms or the dialogues in terms of Article 8 has been centered into the element of control, and we are going to assess that in a moment. But we in somehow tend to forget that there is a prior element, which is direction. And these are not cumulative. It is not direction and control, but rather direction or control. So it can be one or the other. Direction, as defined in the comments of the articles on the state responsibility, is whether the state provide guidelines to a particular group of persons that not act in a specific character of public functionaries of what state in such a way that its direction, it's so mandatory that these people felt compelled to fulfill with such directions, with such prerogatives. And this is different of control because the standard of control, without assessing the specific standards of control, refers that the state retains in somehow a significant power over the person or group of persons which are not state officials, but in such a way that even without directing, giving a specific instructions, it has such a determinative power over the group that it shall be considered the group itself a part of the state. And these rules also, in somehow, you may see them as referring to what it is to be considered de facto organs of the state. You have the jure organs of the state or state officials, which are mandated by law, and then you have de facto organs of the state that without a prerogative, no, a normative prerogative in your judicial or even your legislative, in your national legislation, sorry, the actions committed by them and the involvement of the state in such actions are so strictly related that should be considered as actions of the state. So in the picture you see the contrast group. It is a paramilitary group centered in the 80s, is more precisely between the 1981 and beginning of the late 90s, sorry, which retain a significant power and control over the territory of Nicaragua. Um, this group was said to be a strict, the formation of this group and the creation of this group was said to be back then strictly related to a specific relation with the government of the United States. And this led to the judicial and one of the most important cases in terms of prior developments of rules of attribution by the International Court of Justice, which is the military and paramilitary activities case in and against Nicaragua. So although the article itself does not provide a specific standard of what should be control or what should be direction, the International Court of Justice in 1986, in the case concerning military and paramilitary activities case, said that mere guidance, mere support, mere instruction, mere involvement, participation, or even dialogue with non-state actors is not sufficient. And it says that it should be so representative that it should be effective. And that derives to the back then the elaboration of the standard of the International Court of Justice defined as effective control. Effective control, as defined in the 1986 case and its later developments, and as presented in the comments on the articles on state responsibility, is in such a way that the state has a level of influence that it cannot be influence itself or just mere influence, but rather decisiveness in the operation and management of conducts of such a state. That is that the wording of that state is just sufficient and necessary for this non-state actor to engage in actions, and that the retention of independency or the level of independency is not clear, but not also that there is a certain level of independency, but rather that the group by itself depends strictly on such a state. In such case, the International Court of Justice, as you may see, create a significant higher standard or threshold in order to apply Article 8. And therefore, in that case, at least in relation to what happened to the countries, it was considered that the United States government, although heavily influentiated the country's group, finance that group, supports, provide weaponry and military arsenal in terms of the political and military movements of the groups, in turn to overthrow the back then government of Nicaragua, were just not sufficient because the group retained certain independence. This was later discussed in the prosecution after the in prosecutions of criminal affairs after what happened in the former Yugoslavia. And more precisely, this standard was revisited in the Dusko Tadic case, but also in the in the prosecutor versus Dedalic case, in which, in terms of international criminal law and criminal international law, sorry, the standard should be a threshold not that higher because that standard was defined, at least in the perspective of the ICTY in those two cases, as a standard of state responsibility. But it shouldn't be the same standard when analyzing individual criminal responsibility. And they narrowed the standard to what it is considered to be the global control. And it is, of course, that the group can in somehow retain certain independence, but not as such higher independence as to say that the group may exist or act on its own, but rather that the level of influence of the particular state and the particular person in representation of one state should be sufficient, not yet as defined in the effective control, not yet necessary, in order in the engagement of the proper course of action or the course of action adopted by the non-state actor. And that then decided that analyzing these circumstances, of course, the same elements, financial support, military armament, training, and etc., is not yet sufficient, but it should be in such a level that without such specific elements in a cumulative manner, if possible, the group wouldn't be able to engage in actions. And it is different in the effective control because, of course, in the global or overall control test, it was decided that there is a level of independency and a level of maturity on the non-state actor that could be retained. Then you have Article 9, which is the conduct carried out in the absence or default of official authorities. And it is what happened in situations in which you don't have a particular authority. Let's assume, for example, that there is an overthrow of government, and the group that overthrown the government, although not legally in in charge of functions, decided to exercise those functions of the state. So you don't have any particular authority, you have an absence of authorities as established by law, yet, however, you have persons or a group of persons that engage in such actions. So therefore, if a state is considered to be responsible for actions committed by a person or a group of persons that were acting because there was a non-government or there was a decrease of the level of officials in specific territories, it should be considered yet whatsoever responsibility of the state, because one of the elements of the state is, of course, that you have uh, the responsibility as to administrate your territory. Then you have Article 10, which is conduct of an insurrectional or other types of movement of liberation. This is different from Article 9 because uh, in Article 9, you are not required in somehow to have necessarily conflicts, but rather just the mere absence of state officials. And let me put you an example. In Colombia, there is, and I'm going to be really presenting examples near to Latin America, which I think may elucidate in somehow better, but that could also be replicated to other situations around the globe. But for example, in Colombia, derived from the non-international armed conflict between the FARC group and the government officials, there were territories which were declaring somehow we say it in Spanish, tierra de nadie, or non-administrative territories or territories who belong to nobody. But in such cases, there are particular group of persons which didn't have affiliation to the non-state actor, which is engaged in the non-international armed conflict, or the state officials, that in order to maintain the peace and security of their respective territory, decided to engage in actions propers of the state. So you have civilians or a group of civilians that administrate these territories in which there is no presence of the actor of the non-state actor, but also which is engaged in the conflict, but also there is no presence of the state officials. You have like this third party, and that could happen on Article 9. Yet, however, Article 10 refers to specific cases in which insurrectional movements engage in actions that should be considered as breach of international obligations. And despite being an insurrectional movement, it should be considered an act of the state because as pursuing the principle of self-determination, people is allowed to in somehow I don't, let's say, disregard or not being in conformity with the government. And yet, however, they manifest the intention of that state. And that's why conduct of insurrectional movements is to be considered a manifestations of actions of the state. And this is a clear separation between what is the governmental legal state or the governmental legal authorities that are exercising public functions and manifestations of actions of the state. So in cases of insurrectional and other movements, such as cases of national liberation, it is to be considered that such actions of such group are responsibility of the state. And and lastly, you have one of the most interesting articles, which it was in heavily, although not directly referred, in the case concerning UN diplomatic and consular staff in Tehran, which is the case concerning which is the case concerning conduct acknowledged and adopted by a state as its own. So the UN diplomatic and consular staff in Tehran case is really interesting because it also analyzes elements of Article 9, but also analyzes the questions of Article 11. You have the UN diplomatic and consular staff in Tehran, in order to be very briefly, relates to what happened in the situation in Iran after this conflict between Ayatollah Khomeini and Reza Pahlavi and the in somehow reaching on power of Ayatollah Khomeini after the dethrone of government officials in the capital city and in other cities. So what happened is that Reza Pahlavi, which was the mandate of the government of Iran back then, wasn't somehow protected by the government of the United States, despite that there was a severe inconformity with their actions and there was a lot of accusations regarding misuse of public resources by the people in terms of what the family of Reza Pahlavi was engaging on and actions, a lot of scandal in relation to this family. So there was a major discontent with the administration. And that's, of course, as you may in somehow elucidate, parts of Article 9. And there was a relevant figure, which was the Ayatollah back then, Ayatollah Khomeini, which in somehow, without not engaging, nor directing, nor instructing, was in somehow lifting up the fire as to uh, saying people, let's do something about this because it is not right. What happened is that Reza Pahlavi gets sick, and although he was subject to a prosecution in national forum in Iran, he was in somehow treated. And many people say protected, but the official materials, yet I do not agree with them because I do agree it was protected by the government of the United States. Reza Pahlavi and his family moved to the United States in order to receive the treatment against, I believe, was cancer or a really complex ill. Yet, however, this person was subject to investigations, prosecutions, and sanctions in national forum. So, in the absence of what happened, the Ayatollah and its in somehow militants um, uh, took part of the control of what was happening in Iran. But the major discontent relates to the participation of the government of the United States in somehow their irrestrictive involvement with what's happening with Reza Pahlavi. So the government of the people of Iran in somehow took by force the diplomatic premises, not only in Tehran, but not only in Tehran, but in other municipalities. So the question was to say, what should be and what state is responsible to what happened back then? And there was a particular statement of Ayatollah Khomeini in which he in somehow congratulated and accepted that the actions committed by the group of students that took the diplomatic premises were actions that, although he didn't directly order, were inconsistent with the, in somehow, demands of the people, and he, as a representation of the people, was agreed and accepted the actions committed. And of course, the breach of an international obligation was, of course, the inviolability of diplomatic premises and other prerogatives in terms of diplomatic and consular staffs and diplomatic premises as well, immunities and other subs of other things like that, persecution of non-nationals that are bound to a specific diplomatic agency of your state. So this is one of the clearest example to back then in the moment of the UN diplomatic and consular staff interrogation, the ILC articles were in mere progress, in mere development, sorry. They were not presented, of course, back then to the UN. This was in somehow the inspiration that the ILC took in order to draft Article 11, is to say that when there is, so you may see that the situation in the Tehran case is not as it's a mixed situation between Article 9 and Article 11, because you have the power of Ayatollah, which should be considered Article 9, and then you have that the breach was committed by a group of students, which were not instructed by Ayatollah per se, but that the Ayatollah accepted the actions of the students that took by force the premises. So that's what I'm saying, that although that case didn't refer specifically to the rule of Article 9 and the rule of Article 11, it created a mix in which analyze both situations. So you have, in that case, a double standard of attribution. You have an attribution by Article, what it is today, Article 9, and attribution under Article 11. So there is another part of the Articles on State Responsibility for Internationally Wrongful Act that is normally forget, or it is lost in the pages. And it is because we tend to normally see the disputes as to responsibility, breach of an international attribution of a state conduct, and breach of an international obligation that derivates or in somehow ends in responsibility of the state. Yet, however, there are situations in which it is not a relation between a state or a non-state actors and the state, subject to the question of attribution, but rather that you have a clear participation of a state and its officials. But the question then comes is what happens if such a state is instructed or helped or in somehow guided by another state? So it is not a question of non-state actors, but rather state actors. And what happens when you involve in breaches of international law that you don't directly commit as a state, but rather you support one state to commit? And the Articles on State Responsibility define the rules of aid or assistance in the commission of an internationally wrongful act, direction and control exercise over the commission of an internationally wrongful act, and coercion of another state. So aid or assistance, it's kind of clear by the very terminology, although it has some tricky questions. But by time are not able, we will not able to analyze them. But in essence, is that when you support significantly one state or assist such a state with the elements necessary for the commission of an international wrongful act, you are also responsible for the commission of such international wrongful act. You are not responsible by the action of the third state per se, but rather you are responsible for supporting such third state in committing the international wrongful act. Then the standard is different between aid and assistance. So aid is a help provided by in somehow advices or specific elements in which you in somehow elaborate bilateral meanings, in somehow convene to engage in such actions or suggest, but suggestion, not mere suggestion, but rather such a suggestion in which you compel the other state to commit the international wrongful act. Assistance is more technical in terms that you provide a specific and material means for the commission of the international wrongful act. So the major difference is that aid is more like on material aspects and assistance is more material aspects. Then you have direction and control exercise over the commission of an internationally wrongful act. It's quite similar to the standard of Article 8 in such a way as to determine that the control exercise of other state is such, this is way too decisive that the state was in somehow uh, mentored by you in such a way that it wanted to commit the action. So the control is that you provide all necessary means, and you have such influence in the other state that your word should be considered word of the other state as well. And this is different of coercion. And this is the possibly the most difficult rule, because many people may say, well, coercion is in somehow part of direction. No. And there is an element of willingness. So coercion, as a difference to the previous standard, is that the state that actually commit the internationally wrongful act desire to heavily influenced or assisted, aid, or controlled by you, but it retains some determination. In coercion, you were deprived of such a determination that you were obliged to engage in internationally wrongful act. And that's the major difference. Then we move to the second part of the Articles on State Responsibility, which is the breach of an international obligation, which also had a set of rules in relation to what should be considered breach of an international obligation. But in essence, is that a state can be held only responsible for an internationally wrongful act if it has breached its international obligations, such as treaty obligations, customary international law obligations, general principle application of general principles of international law. And one of the most significant, of course, is a violation or actions contrary to peremptory norms. Peremptory norms of jus cogens norms are norms defined by not only the Articles on State Responsibility, but also the Vienna Convention and the law of the treaties on major practices of the state as norms defined by the international community to be peremptory, that is, that are applicable to everyone, and that you cannot object to such obligations because they are inherent to the treatment of people and the rights of the states. And the clear example of a jus cogens obligation is, of course, the violation against the principle, the jus cogens norms are related to the prohibition or commission of commissions of acts of torture. But then it comes the second favorite part of myself, at least in terms of the articles on state responsibility, which are the circumstances precluding wrongfulness. This is not, I want to make a previous statement that this is not like a linear presentation of the articles, but rather I am focusing of in the what it are one in which those in those articles, sorry, that are of such significant relevance for the international community that have been majorly analyzed in different case law. So you have circumstances precluding wrongfulness. Circumstances precluding wrongfulness refer to certain circumstances in which the state, although is not in somehow exempt or exempted to not to breach the international obligation, but rather that the particular circumstances foresee that that it was required to breach the international obligation. And those circumstances are, of course, consent, self-defense, countermeasures, force majeure, distress, and necessity. I'm not going to focus individually on each and every one of them, but maybe in the question part because we don't have enough time. But in essence, is what you may see from the title. Consent is that the state that was affected by um, by the breach of the international obligation consent to such violation. Self-defense is that you engage in an action in order to, in a proportionate and necessary response for another, in order to avoid the breach of an international obligation subject to your own self. Countermeasures are different from self-defense are and have actually, I believe, from Article 49 of the Articles of State Responsibility, a whole set of development in the Articles on State Responsibility. And countermeasures is that as a difference of self-defense, you are not active in such a ways in order to avoid the violation, but rather you suffer a violation of an international obligation. So you engage in a violation directed or intended for the first committing violated state to fulfill with its primary obligation. So countermeasures, as defined in the articles on the state responsibility, are of course of a temporary character. And force majeure is, as the word force majeure in somehow defines situations which cannot be resisted by the state, which are may be governed by acts that are not foreseeable, are not being capable. The standard defining force majeure and force majeure or force majeure is that should be actions, whether or both unforeseeable and unresistible by the state. And those words are really, really difficult to analyze in international law because there are only few elements in which you may demonstrate that you were subject to force majeure. And the most clear example is, of course, actions of of the nature. But even so, questions have been presented as to whether certain actions of the nature or natural disasters could be in somehow being foreseeable on being foreseen, sorry, by states in order to avoid other violations of international obligations. Let's assume the following. You have an obligation to respect the right to life in all circumstances and not to engage in actions of arbitrary deprivation of life. Yet, however, there are some cases, in both, not only in case law, but also in state general practice, in which by consequence of forces of the nature, you are required to in somehow privilege the right to life of one people against the other due to the access of population and the facility to enter to one territory, the capabilities and the financial capabilities of your state to attend your whole population. And questions are presented more precisely more precisely in relation to floatings, whether states are in somehow able to foresee this type of situations. This is more complex in other situations in which the action of the nature is in somehow derived from actions, minimal contributions of actions of the international community, such as climate change or even the erosion of receding coastlines. Mm, so, which is a fundamental element of the Jessup case law this year, but I'm not allowed to enter this directly. In this, you have necessity. I'm going to put last distress. You have necessity is that you were live to such a situation that if you didn't engage in such an action, you may in somehow create a greater violation to yourself or to the international community. Necessity, as similar to what happens to self-defense, should be measures that are proportional and that are sufficient and essential, and that there are no other alternative means in order to avoid another international violation. So it requires you to reach an international obligation in order to avoid a violation of another. And distress is possibly one of the most interesting. I'm going to pause my presentation, at least my slides, if I'm allowed to. I don't know how to do that. Okay. Um, but okay. So I'm going to read you the definition of distress, which is really interesting because many people normally misuse the standard of distress in international law. And the standard of distress, as defined in the articles on state responsibility for international legal act, is presented in Article 24 of the articles on the state responsibility. And it says the following. It says that the wrongfulness of an act of a state not in conformity with an international obligation of that state is precluded if the author of the act in question has no other reasonable way in a situation of distress of saving the author's life or the lives of other persons entrusted to the author's care, in which and there are of course certain in somehow um, exceptions or requirements or prerogatives which are defined in paragraph 2 of Article 24, which are that the situation of distress is due either alone or in combination with other factors to the conduct of the state invoking it, or that the act in question is likely to create a comparable graded peril. So one of the fundamental questions with distress is how is any different distress to other situations such as self-defense or even necessity. And that's a trigger question because distress is a specific provision in which entrusted to situations of perils in which a person has a duty of care, whether by itself, whether I am protecting my own integrity, or rather protecting the integrity of other persons. So I was left to no other choice. The major difference between self-defense, can you hear me? Because I hear a comment that there was like um, that there was like
We can hear you.
problems. Okay, so just to clarify, I said that I will pause the presentation, but I will begin because I wanted to focus on the reading of distress, and because it's one of the most complex rules in terms, but not even that complex rules of circumstances precluding wrongfulness. Um, and yeah, of course, the slides will be accessible to you after the presentation and after the session. So what I was just saying is that distress it created a specific set of rules in which the articles preclude the wrongfulness of a conduct adopted by the state agent in circumstances where the agent had no other reasonable way of saving life, whether its life or the life of others. Unlike situations of force majeure on Article 23, a person acting under distress is not, how to say it, like, is not acting involuntarily, because that's normally what happens in force majeure, is that is, for example, in force majeure, because it is unforeseeable and it is unresistible, you are acting in somehow preceded by your instincts. Yet, however, in distress, a person is acting voluntarily. It's well aware that its action it's going to create a violation of an international obligation. So nor is a case of choosing between compliance with international law and other legitimate interests of the state, such as characterized in situations of necessity. Rather, the interest concerned is the immediate of not necessity, sorry, but rather the immediate require of saving lives. So necessity should, I remember that I was told back in the master degree and in some courses that I took in relation to the Hague Academy, that you can see necessity as a more general standard and distress and force majeure as well, but distress is a specific situation that refers to the protection of life and why it was created. Because there are situations which you can foresee that you can resist, but the immediate requirement of saving your life or saving the life of others compels you or drives you or triggers that in somehow mindset of self-protection or even survival. And that's the fundamental question of distress. And that's the major difference. And that's why I wanted to do like a brief pause because I normally receive questions in and what is the difference between distress and the other standards or even self-defense, because you can act in self-defense when you are protecting your life or the life of others. But remember that we are not analyzing self-defense as an action of individuals in relation to the standard of the self-defense, but rather self-defense of the state. One of the major cases of self-defense when analyzing whether the standard should be applicable or not was the old platform case, in which analyzing whether certain attacks to oil platforms um, when assessing the responsibility of the government of the United States and the government of Iran should be considered action of self-defense just because they were defending the territorial integrity of one state. So no lives were imperiled per se, but rather the integrity of the territory, like an invasion. So take a look, for example, without entering into the political scenario, what happened if one state is uh, closely, willingly to enter to your territory in order to create a situation or to engage in a process of occupation. By self-defense, you are allowed to protect the territorial integrity of your state. The situation of distress is rather whether a state agent commits a violation, for example, of other international obligations, such as, for example, the even own right to life, when it is threatening its own life or the life of others. You see that there is a difference. Of course, you may argue that a situation of occupation is, of course, a situation that may pose a threat to your own life. But the stress comes to be in somehow precise to the specific circumstance in which your life is an immediate peril, and that there is no other reasonable way in order for you to protect your life. So that's in essence what happens in the circumstances precluding wrongfulness. I'm going to share my screen again. Can you confirm whether you can see them or not?
Not yet. Oh, now yes.
Okay.
Thank you.
Okay, thanks. So, what is the major consequence of proving the attribution of a conduct and the breach of an international obligation? And of course, that there is no circumstance precluding wrongfulness that in somehow uh, derogates the responsibility of the state, and it is the reparation. So the articles on state responsibility, and as it was considered by the International Court of Justice in many case law, but more precisely in the Capchico-Bonadimares case, have defined that the specific chapter of reparation and the specific forms of reparation, sorry, not rather the chapter in its entirety, but rather that the specific forms of reparation are rules of customary international law. So reparation, of course, is in somehow a remedy. How are we going to create a relief for the action in which I engage on? Reparation can take many forms depending on the nature of the International Wrongful Act and the consequences of such International Wrongful Act. And this includes restitution in kind, compensation, satisfaction, and guarantees of non-repetition. So one of the most interesting questions that you may ever face in the international community prior to entering into discussion of restitution is when you have demonstrated that there is a breach of an international obligation and that the conduct is attributable by one of the rules of between Article 4 and Article 11 of the Articles on State Responsibility, what remedy I am allowed or will I as a state representative request? And it is not that simple. And that is because, as presented and depicted in the rules of state responsibility, the remedies in nature cannot be cumulative. And normally you cannot ask one and the other. You may be able to request that in some scenarios it should be one or the other, as normally defined in the articles on state responsibility, but it is really difficult to demonstrate that you may be entitled to request of three types of remedy. And that is because the articles on state responsibility presented the forms of remedies as a letter. So you have to try to do this first, then the other, and lastly the other. But the International Court of Justice, once again, has created certain criteria, precisely in the Capchico-Bonadimares case, in the North Sea continental shelf cases, in which in some circumstances, due to the damage caused, the relief may generate multiplicity of remedies. But the general rule for you to take and bear in mind is this escalonated figure in which you cannot have one without exhausting the other. So the first thing that you may try or you are allowed to request is, but rather you should demonstrate in terms of your request as a representative of the state, is restitution. So if you're going directly with the other forms of reparation, you somehow first have to demonstrate that this first form is not possible. So restitution is reestablish the situation which existed before the wrongful act was committed, provided and to the extent that the restitution is not materially impossible and that does not involve a burden out of all proportion to benefit deriving from restitution instead of compensation. So you can see restitution is, in essence, try to come back the situation to the way it was before. But there are some situations in which it is not possible. Imagine yourself one of those situations. And of course, the lightest and most clear example is what happened when I kill other person or kill a group of people. It is not possible for me to restitute the right to life because these people has unfortunately already been permanently damaged. So you have to come to other situations. So that's the material impossibility. So when analyzing the material impossibility is that it is possible to in somehow going back in time and create a situation prior to the violation. Yet, however, there are some situations in which it's likely possible for you to restitute in kind. That is what we were just discussing to go back the travel, kind of engaging in a machine time processes, in the machine time process and turn back time. But there are situations in which, although being possible, that will pose a significant benefit to the affected party, totally disproportionate to the damage caused. So that's what Article B creates. So it says that does not involve paragraph B, sorry, so paragraph B of the article of restitution refers is that does not involve a burden out of all proportion to the benefit deriving from restitution. So let's assume that I built what was destroyed was an important religious center. It is possible for me to reconstruct this religious center independently of the religion that we were discussing on. But what should not be is that the engagement in costs and the in somehow expenses for restituting or recreating this specific building are disproportionate to what will happen if I decided just to compensate. Whether it will be easier to a state to just simply give you the money because it will be, and this is a really terrible word, but it's the most precise, it's most cheaper, it's more is less expensive, most cheaper. So if it is consistently expensive, it creates a whole situation in which the causing state of the internationally wrongful act engage in actions that are more expensive than the situation prior to the violation, then you shall go immediately to compensation because it will be better, at least for the state that creates the affectation. And this particular paragraph has been subject to a lot of criticism, especially when you are analyzing situations of armed conflicts, because there are places, not only religious places, but also cultural and even community places that are such of a significant relevance that compensation well, it's not sufficient just to remedy what happened. And that was, for example, what the International Court of Justice analyzed when some civil infrastructure that was damaged under the civil war and the Bosnian in the ex-Yugoslavia conflict and the separation of the former Yugoslavia and succession of all states and everything that happened, at least in the geographical context, is that many people in somehow said that this article was in somehow a benefit from the affecting state rather than a benefit from the affected state. Then you have compensation, and I want to say that compensation, and you should bear really in mind the following: compensation is not entirely about money. Uh, although majorly compensation is possibly offering alternatives without having to engage in a specific refund or in a specific allocation of money that in somehow will repair the damage caused. So I can compensate by, for example, using other means. You have economic compensation, but you have administrative, moral, or even significance compensation. The most common way of compensation is, of course, the economic way because it is the most in somehow reliable. It's that when, well, it was not possible, the restitution. But the difference of material compensation and economic compensation and material compensation and restitution is that there is no allocation in money given to one state, but rather that I give you directly the specific source. So material compensation is in somehow differ from restitution because restitution is going back the time machine. So I have to somehow lead the situation to the state of art it was before prior to the situation. So let's take for example the situation of the building. If I go to restitution in kind, I should do the best under my capabilities to recreate the very same exact building because that's the restitution. I will give you back the building that you lost. In compensation, I can offer you a set of goods, a set of materials, which are not, of course, the building per se, but that will in somehow compensate, sorry for the redundancy, will in somehow level up the damage caused. You will not get back the specific good or the specific situation that was active prior to the wrongful act, but you will have something in somehow similar or that in somehow will level up to the measure of that specific situation. The compensation shall cover any financially accessible damage, including loss of profits, insofar as it is established. And one of the fundamental questions in relation to compensation is the in somehow application of interest, whether it is acceptable to apply interest to compensation. Under the perspective of the articles on the state responsibility, it is permissible, but it has certain limitations. Yet, however, if their interests contribute to the standard of full reparation, they are allowed under customary international law. And then you have the measures of satisfaction. Satisfaction may consist of acknowledging the breach of our expressing regret, a formal apology, or another appropriate modality that shouldn't be out of proportion to the injury and may not take a form of humiliated to the responsibility still. So one question that you may be having is, well, normally when you somehow engage in process of restitution, engage on process of compensation, they are normally in somehow a campaign or go hand with measures of satisfaction, a public apology, a public recognition of responsibility. Yet, however, as the standard was presented by the articles on state responsibility, satisfaction in old-fashioned way should be the last resource. Yet, however, the International Court of Justice, once again, in my perspective, really properly decided that you, in certain situations, due to the nature of the international wrongful act, may engage into in somehow consequent or in somehow not alternative, but rather cumulative presentative methods of remedy. So you have cases in which you breach the life to life. Satisfaction will not be enough, and compensation will not be enough because there is no enough money in order to in somehow compensate the loss of life. And there is no sufficient recognition of responsibility or other actions that we're going to see that will in somehow fully reparate the victims or the state affected as representing the victims. So if you give state officials, well, just giving money for that state official in the view of the International Court of Justice, I believe really proper, is not just sufficient because it will be kind of vague just to say, well, this specific official or this specific action caused that, and that's all, especially when there are human rights involved. But it is also not enough, sorry, to just say, well, I'm sorry, and that's it, and it's happily ever after. You have to, in certain situations, such as human rights law, international humanitarian law, or access to a specific services, uh, to, when committing internationally wrongful acts, apply as a cumulative and in same level standards of reparation, not alternative, but whether you can present them both, and the justice, if a good justice, of course, should allocate, if possible, both. There are other forms of satisfaction that are normally not used, at least in interstate disputes, but just in specific circumstances in which certain policies of their states are the ones that are generating the consequences of the breaching of the international wrongful act, or the act or the policy, whether a law, whether a decree, is the international wrongful act per se. So a measure of satisfaction is, of course, to change the law or policies that your state enacts that are in somehow generating or are the direct source of the violation or the breach of international law. And you can also engage in preventive measures. Preventive measures are not normally allocated in interstate dispute, but rather in human rights disputes. Changes of law policies yet have been allocated by the International Court of Justice, including in the Capchico Bonadamares case and in the case concerning the Temple of Praviar. Other case was because the law that was creating the delimitation of the Temple of Praviar was, in the view of the court, is somehow um, part of the question of whether it should be, and the state requested at that moment uh, mm, the that case was really complex because it's a case of acquiescence, but one state acquiesced and therefore accepted the delimitation, but I believe 2 years later, after the standard of acquiescence was applicable, decided to enact a law in which it put the Temple of Praviar part of its territory, and therefore the court says you have to annul or change the delimitation because you previously accepted the delimitation defined by the other state. There is another case concerning, it's a really long name case, which is the case concerning sovereignty over Pedra Blanca. I believe it was Pulau Dapote, Middle Rocks, and South Ledge, mm, which also questions of the limitations of specific formations in sea should be considered or no by decree actions per se, uh, in conformity or inconsistent with international obligations. And preventive measures are guarantees as a manifestation of guarantees of non-repetition may involve, for example, creation of programs of education, awareness raising campaigns, or other forms of intervention in order to avoid a future commission of such or a similar conduct. Finally, there are, because I know I passed my time by 2 minutes now, there are additional relevant provisions in the articles on state responsibility that you should really look up to, which are the invocation of a state responsibility of a state, which is in somehow the procedural rules that the articles on state responsibility present in order for you to notify that you were injured as a state. It also present what should be the proper standard, what should be the proper analysis of notification, public notice of the commission, how to normally attempt to resolve the dispute, what means of resolution of disputes you may engage in. And then you have one of the most interesting chapters, which is serious breaches of obligations under parental norms of general and international law. It's a really brief chapter of the articles on state responsibility that, in essence, portray that the responsibility of the states when violating obligations under parental norms or use quadrants norms that are depicted or enshrined in general international law, in terms of the consequences of such serious breaches, the consequence should be consistent with the breach itself. And in order to conclude, and I don't know if there is particular questions in relation to this presentation, before I give you some advice when reading the articles on state responsibility, is that the articles on state responsibility, as you may kind of derive from this presentation, are important in the framework of international law because they outline the legal consequences of state actions that violate international law. The application in practice, as we were discussing, is that they are applying practice to hold the states accountable for their actions and to provide reparations to state victims and people injured represented by a state. And that the application per se, as the International Court of Justice defined, is somehow mixed or varies depending on which provision are you going, which provision you intend to apply. So it is a common mistake to say that the articles on state responsibility in its entirety are part of customary international law. It will be great though, but at least from judicial perspective, the International Court of Justice has been quite limitative in analyzing which rules are part of customary international law and which are not. So the question that remains is what happens if there is a provision that normally the International Court of Justice has not considered to be part of customary international law? Then you have to analyze which type of source of law it represents or enshrines, and analyze whether the rule was worked by the International Law Commission as a part of crystallization or as a part of codification of customary international law. Normally, some articles which are not to be considered part of customary international law of ARSIWA are considered to be instruments of soft law. Some are defined by state practice as reflection of principles of general international law, which is a more tricky question, sorry. And finally, the role of state responsibility in international law is fundamental because uh, Jessup competition, as most of moot court competitions, is defined in to answer the question of who is responsible for what is responsible and what should be the consequence. So the relevance of the articles on state responsibility derives on that. It derives from the fundamental principle of international law to maintain peace and security, but also that states are responsible for their own actions. It holds a state accountable for their actions and help to promote, at least in it is intended, not necessarily helps to promote, but it is intended to promote peaceful relation between states. So normally the rules of the Articles on State Responsibility, what in essence they were in some created by the International Law Commission as an intention to avoid escalated conflicts, but rather to lay down the conflicts to mere judicial disputes. So we are going to solve our disputes in the judicial perspective and not in the use of force or other situations of violence perspective. Yet, however, as you may see from the vast majority of cases in which the rules of attribution have been analyzed, sorry, by the International Court of Justice or either other forums, because you have the non-necessarily judicial bodies, but what it is called quasi-judicial bodies, such as the um, World Chamber of Commerce or even the Appeals Chamber of the World Trade Organization, which is now really in a really complex situation. Or arbitral awards have analyzed in disputes not only in relation to the typical questions of human rights, delimitation, but also in terms of economic obligations under international law, trade obligations under international law. There is one particular case in which Article 5, Article 8, and Article 9 of the Articles on the State Responsibility were analyzed, and it was under the Chamber of the World Trade Organization in the preliminary chamber of the World Trade Organization. The case concerning the trade of goods and services from and in Ukraine. It's a case of 2019, if I'm not mistaken, 2019, 2020, prior to the crisis of the appeals chamber of the World Trade Organization, in which was analyzed whether certain actions committed by military forces that restrain commerce and the trade of goods and services in the frontier between Ukraine and the government of Russia were consistent with the rules of the World Trade Organization, and most importantly, whether the actions of these particular militias were attributable to the government of Russia. So that's an example in which it is not only the rules are not only intended to apply to a specific uh, how to say it, specialized bodies of international law, but it are intended as part of customary international law to be applicable to the possibility of situations in which international relations may be held by states. Having said that, I think my time has, of course, over by 9 minutes. But I don't know, Claudia, if there is time for questions, whether there are questions or not. And thank you for the attention. And I hope that this session has been at least useful for the preparation of the moot court, but in general to your international law knowledge.